K.V. Dhananjay, Senior Advocate of the Supreme Court of India. Dhananjay, a very warm welcome to you. This is something which has been, hogging the limelight, so far as Karnataka is concerned. And there are lots of pros and cons about this, a big controversy which broke. I'll come to the legalese, the legal aspect of it, Dhananjay, but do you think there is merit, if you were T.J. Abraham's lawyer, do you see merit in what Abraham has presented to Governor Gehlot?
Well, I think it's slightly complicated. That is because the Prevention of Corruption Act underwent a good deal of amendment in 2018. So, by virtue of that amendment, it's now more difficult to prosecute public servants than it was the case before. Number one. Number two, he's of course made several allegations against the chief minister and all of that. And the difficulty for the governor would be to obviously follow the new law, which actually says that the governor will give an opportunity to Mr. Siddaramaiah before proceeding. Number one. Number two, there is also a time span that has been put here, which is 3 months, and then a further period of 1 month in case of extraordinary legal difficulty. So what I would suggest is, or rather what I would point out is that I think it's a tough case. It's a difficult case. No doubt the allegation is that Mr. Siddaramaiah occupied a great position of public power, and while he was that public servant, his wife stood to benefit in a very corrupt manner, in a glaringly disproportionate manner, and all of that. That is fine, but to invoke the provisions of the Prevention of Corruption Act, you need to specifically allege that the public servant against whom you wish to proceed positively did something, or if he had a duty to act, he failed to act. Now, I doubt if that part of government is present in his complaint. He is no doubt making a wonderful moral case, but as far as the law is concerned, sometimes you should know that the law and morality diverge a bit. Mr. Siddaramaiah being in great position of power, I think the allegation, now let's take a hypothetical scenario.
Okay.
The hypothetical scenario would be if Mr. Siddaramaiah was in charge of denotification and then he went on to denotify lands. Now, what is denotification? Now, in land acquisition matters, once a land is acquired, it becomes the absolute property of the government. Therefore, the private character is completely lost. The owners from whom, the original previous landowners from whom the land came to be acquired are now only nominal persons. The land is now the absolute property of the state government.
Right.
Denotification is a process by which you reverse that. You essentially say, I am now going to, somebody in the government is going to say, by this act of denotification, I am going to give back this government property back to that private person from whom it was acquired.
Right.
Now, the denotification is a positive order that has to be passed. Now, I don't think the allegation is that Mr. Siddaramaiah was in fact the person who authored the denotification order. Now, short of that, the question essentially from you was, what would I do? I would have said that, look, the case actually appears to be difficult to bring in Mr. Siddaramaiah in this case, because the law is the law. I probably disagree with the law. I believe the law should have been slightly different, but the law is what it is. So the law would want somebody to allege that Mr. Siddaramaiah was in fact the one who authored the denotification, knowing fully
All
well
right.
he was doing so to benefit his wife.